Hi, in this video we're going to talk about why powers of attorney are so important for Medicaid eligibility and whether or not a person diagnosed with Alzheimer's or dementia can sign a power of attorney. So let's start with that. What happens when a person with Alzheimer's or dementia needs a power of attorney and someone puts the document in front of that person and makes them sign? Well, we have an issue of capacity. We don't know if that person has the capacity to understand what the power of attorney is. And that can create problems within the family, and a person within the family can say, how can you have that sign that power of attorney when he was diagnosed with Alzheimer's or dementia? And that can create problems for the person who made that person sign the power of attorney. And so it can make allegations of elder abuse and other things. So the best practice is not to have that person diagnosed with Alzheimer's or dementia sign a power of attorney, unless, let's say, a doctor says that the diagnosis is a mild Alzheimer's or dementia and the person still understands what is about to sign. So we have to be very careful with that, because again, number one, it can be an invalid power of attorney, and number two, the person who made the effort to get that power of attorney signed can be accused of elder abuse. So best practice is not to do it. The law allows that a person with what is called diminished capacity still sign estate planning documents, but again, we have to make sure that that person understands what is signing, and that is only an attorney or a doctor can help you with that. That being said, why powers of attorneys are so important for Medicaid eligibility. In prior videos, I explained that most of the things that we attorneys do, we do it through the power of attorney. So we have the agent under the power of attorney sign all the documents. We have the agent do a number of different things. So what happens if a person who is applying for Medicaid benefits has more money than the law allows you to have to qualify for Medicaid? Or what happens if we need to transfer money to, let's say, a trust or a pool trust to get the benefit? Or what happens if we have to sell property and then do some sort of Medicaid planning, like a personal service contract, and you know, the power of attorney doesn't have those powers? Again, we will end up in guardianship court, and that is not good. It's not a good idea to end up in guardianship court. Why? Because the judge may say, well, I don't want this, I don't like this Medicaid planning that you're proposing, and therefore we're gonna say no, and that goes your plan. I mean, you know, you won't be able to do Medicaid planning. So with the power of attorney, if we have the correct powers there, and they are again initialed and discussed with the client, and the power of attorney was prepared when the person had the capacity to understand everything, then we can do everything we want with the Medicaid application. So let's say we need to sell property, we can use the power of attorney, because the power of attorney says you are authorized to sell property, and you can use the proceeds later to transfer to, let's say, a pool trust. The power of attorney says so, therefore we can do it. Or we can transfer their proceeds to a family member and enter into a personal service contract. We can do it because the power of attorney says so. and nobody's gonna question the Medicaid social worker or the person who is doing the processing the Medicaid application is not going to contest that, because he's gonna see that the power of attorney contains those documents and the agent is authorized to do whatever we need to do. Also, we can use it for accessing to bank accounts and transfer money from one account to another. Let's say from the ill spouse to the healthy spouse. So we can do that using the power of attorney. So very important things that the power of attorney allows us to do when applying for Medicaid. And again, if we don't have those powers, we may end up in guardianship court, and the judge may say, I'm sorry, I don't like the plan as you propose. You're gonna use your money to pay for the care of this person, and that's what it is. So your assets will be depleted and you won't accomplish your goals. Again, get good powers of attorney. Always talk to either an estate planning attorney or elder law attorney when discussing powers of attorney. Thank you very much.